Okay, I'd like to call the Mentor City Council work session for May 6, 2025 to order. We'll start with the pledge to the flag. All right, good evening, everyone. Tonight's work session. Oh, I'm sorry. Well, I was going to call a roll after that. Yeah. Tonight's work session is in regards to short-term rentals. We're going to start with Julie calling the roll, please.
Mr. Kirchner?
Yes.
Mr. Krieger?
Yes.
Mr. Martin?
Yes.
Mr. Blake?
Yes.
Mr. Donovan?
Here.
Mrs. Dowling? Here. Mr. Freeman?
Okay. So tonight's topic, short-term rentals, Airbnbs. Ken, how about if I come to you first?
Thank you, Mr. President. So, Council, what we've given you earlier is sort of a draft of what we put together based on some input that we got from council members. And essentially, as before we get into going through this new chapter 752 as proposed, we're saying that what we tried to do is cobble together some of the central points that are made in most legislation that we see that regulate short-term rentals in other communities. Mrs. Cantanzariti is the author of this section. She and I worked together on agreeing on what we wanted to see, but of course, it's a draft. So some of this may agree with what you're after, some of this may need to be amended to add. You may decide to throw the whole thing out, but we'll go through that here shortly. Before we do that, I did want to mention, because what looms over anything that we do here is what the state legislature is considering. As it stands right now, we're aware of 3 bills in the current session of the legislature that impact short-term rentals. The first one, so there's a Senate Bill 104 and a House Bill 109 that are essentially parrot one another. They're very much the same, and I suspect if either of these if there's legs in both houses, then these will probably get consolidated. But in both cases, they essentially limit pretty much all local control over the issue as to whether or not we can put rules in place, certainly not be able to prohibit them. And then in both cases, it adds the ability for lodging tax in all cases, and that would include everything that falls under the rental definition, whether that's single room, apartments, houses, etc. And then the other is House Bill 161, which essentially does not really impact local control, but does extend both the right to charge both lodging taxes and state and local sales taxes on that. As you can imagine, most of the local jurisdictions are a little bit more favorable toward that one. When I look at, I find it a little bit, I don't want to say humorous, but interesting that when I look at the sponsors of those bills, the ones that provide the greatest prohibition on local control are some of those members of the legislature that have a background in real estate, either development or some relationship to that industry. So take that for what you will. So from what we understand, all of those are either in or recently completed with committee review. So we expect that something will likely happen. Don't know what that is yet, and so I would say that we would be relying on if there's a section that we want to control locally, if in fact we adopt some local legislation on this beyond what you have already done, essentially prohibiting these, then I would say that we want to be active in supporting our point of view that we should continue to have the ability to regulate, and so that may require a little bit of effort on behalf of our council to talk to our legislators about our position on that. But I know we're here to talk exactly about that tonight, so we'll move on into this. Any questions on that? We aren't the ones that can answer those clearly. I just know that I can say that there is a lot of activity in Columbus right now.
Mr. President?
Is there anything that discusses location within a community on the state level that you've seen?
Not really, because again, these two ordinances that pretty much do the same thing limit very much everything that the local authorities can do. So it doesn't really get in so much. I mean, keep in mind, these bills are pretty long, and I'm just really reviewing the summaries. But it would appear that there's very little that would speak to that at all. Probably nothing.
Thank you.
Okay, so we'll move on into our recommendation here on this draft legislation. So again, statement of purpose gets us started on that, and essentially it's a fairly generic statement. We all understand why we're here and what we intend to do with this. Under definitions, Kathy, you want to speak to that? We'll just go through this section by section and just kind of summarize what it is, what it says, and perhaps some reason why this is included as opposed to other things being excluded. And then obviously open to any thoughts or questions as we progress through. Kathy?
Thank you, Mr. Filipiak. Members of council, obviously, we have looked at this, and as has the law department over the course of many months. And when you reviewed the prohibition ordinance under ordinance 24-0-071, Mr. Zeman had provided you with a list of definitions and so forth. So we started with those and then added to it, recognizing that if they weren't prohibited, what are some of the additional language that we would need? I think the main thing is if you are the owner of the dwelling but you don't live within the area, you would have to have a caretaker that would be within 30 minutes of the property so that they would be able to be called upon at any time, 24/7. Again, if the owner of the property would not be available. Then there's the basic definitions. Again, some of these which you've already seen: booking service, what a guest room is, hosting platforms. The owner is just the owner of record. And then we chose to, you could call it whatever you want. Some people called it certificates. We went with the word permit, a short-term rental permit, as duly issued by the city. And then you have the rental itself is a dwelling. And again, based on, as Mr. Filipiak indicated, based on some of the feedback, this would be limited to particular districts. If there's any questions on the definitions, they're pretty straightforward and self-explanatory, but I can go into the applicability and city capacity limits, which are pretty important, and we would be looking for some feedback on. I think when Mr. Filipiak and I talked about this, we thought it made most sense to hit the most prominent districts in the city, which would be the R2, R3, and R4 single-family residential districts. Obviously, that would exclude RVGs, which there are numerous ones, and conservation zones and so forth. So then that would be up for discussion if that would be something you would want to modify if this were to move forward. The other information that's of note to you is how the rentals are limited. There's a capacity limit formula that we came up with, and it reads under item B of that section, which indicates that the maximum number of short-term rentals allowed in the city will be based on a ratio of 1 permit per 2,000 population with the city as recorded by the U.S. Census, closest number divisible by 4, that number being the number of wards in the city. So if you were to take that population of 48,000 and then you had divided that by the 2,000 and then again divided by 4, you're limited to 6 per ward.
So if I could just touch on that as well. And again, the thinking behind that was so that we didn't have a proliferation of these short-term rental properties really concentrated in one area. I mean, the reality is most of these are rental homes or investment homes, And there are certain sections of the city where real estate prices are a little bit lower and a little bit more attainable, where certainly there are areas of the city where we have more rental properties than others. We didn't want to see a proliferation in one particular area, and also leave for the opportunity for all of the wards to have the same level of benefit if we perceive these as having benefit throughout the city. So certainly that formula is changeable to whatever council prefers. It was our thinking that putting a limit on these would provide some of the alleviate some of the concern that might be expressed by by some of our residents that we're just opening the doors wide.
And then the next section talks about the, yep,
Was there consideration given to how would you come up with that 6? So say, for example, if there's 26 in that particular ward, how do you choose 6 out of 26?
Well, it assumes right now that, your current regulations, which have always been in place, which council really just clarified with your most recent legislation, that these were not permitted in the city to begin with.
Right.
So you assume from the starting point that there are 0 in the city. We know that's not the case, but you assume that if you were creating this with the knowledge that no one was violating your existing regulations, then this would be how you would proceed. The question becomes, and that's a question for council, if you adopt a new section, what do you do with those that are operating, and how do you treat them? Do you give them preferential treatment in terms of permitting? Do you there are a lot of different ways to come up with a manner in which to dole out these permits, whatever that number is. And again, if your inclination is to treat the existing properties favorably, then that number can change. We were just suggesting that the best way to approach this might be to provide equal access and equal limitations per ward.
Okay. All right, thank you.
so under the permit required section, it does define, and again, just to reemphasize what we've talked about in the past, but this is only for a rental of a home for a period of less than 30 days. This is not a portion of the home, this is just the entire house, because we did, in the other ordinance, remove that option to rent parts of the home. So this would be a whole house rental. The way this was drafted was that there would be a permit requirement every year. That is different from the current maintenance, the current long-term rental requirements, which requires a permit renewal every 2 years. This would allow for the city to reevaluate an application every year. The other thing here to note is at the time of a renewal, for example, and I'm jumping ahead a little bit, but it goes hand in hand with this, that you would have to renew it before the end of the year. So you would have until December 1st of that year to start the renewal process. If you're late, you get a late fee. And if you pass that deadline and December 31st comes and your permit has expired, it's expired and you're on a wait list. So there's a couple of ways to handle it. And we saw that handled in that way in some of the other communities that we evaluated. So that is, again, one approach. It doesn't have to be the way it's done, but that was a suggestion that we're putting out to you.
The point being that the responsibility is on the permit holder to make sure that they're complying with that annual renewal, and also gives us the opportunity to do an annual inspection if we choose to do so, which we likely would. The annual would be more frequent than our every other year inspection requirements for rental properties throughout the city. And again, because of the nature of this, we think that greater level of frequency is probably warranted.
Mr. President? Do we know how many rentals we have in the city that are registered with the city? I know we do inspections, so not an exact, but at least a ballpark number.
Well, none are registered because we don't
But for the inspections?
provide for them. Oh, rental properties overall? Oh, wow.
yeah.
Do you know the number?
Oh, you know what, I can certainly give you that number. It's quite a bit, just regular rentals. I thought you meant,
No, I
Short-term.
just mean right now, how many rentals? Because I know that they do the biannual inspections, so.
yes. I can get back to you on the number. I don't want to misquote that. so,
Okay.
Yeah. The next section talks about the application. Pretty straightforward information here. What would we would require of every applicant? You can see that on page 3. Just goes down the list of contact information, proof of insurance, obviously knowing the hosting platforms that you're putting this information on, number of bedrooms in the dwelling, number of parking spaces, because there is a parking space calculation requirement that's partially in the definitions and then also under the standards.
So, just if I can jump in
Sure.
there, Kathy. So, again, what's key here is that, this is control within the neighborhoods. So, you have someone, if the owner doesn't reside within 30 minutes of the property, you have to designate a caretaker who is. So somebody that's available immediately or very shortly thereafter if a problem comes up. We need to know what the number of bedrooms are because the number of guests are tied to the number of bedrooms. And there's a ratio on that. It's what, two per bedroom, Kathy?
Yes,
Plus-
2 per bedroom plus additional 3 total.
plus 3, so you allow for an accommodation for people to maybe sleep on the sofas and that, especially with kids and that. Obviously, good contact information. Parking spaces, there have to be at least a number of parking spaces that equate to the number of bedrooms. Again, it prohibits parking on the street, which we have a prohibition against overnight parking anyway. But again, we don't want there to be an expectation that people will just park on the street in the neighborhood and again, disrupt those who may not know our rules on parking at night. But again, they're expected to be able to show that they have enough parking at the property to be able to accommodate the number of guests. Obviously, proof of insurance, where there are hosting platforms that they're using. Those are kind of the hallmarks of it. And again, those are fairly straightforward hallmarks that you're going to find in most communities that regulate these properties.
President?
Proof of insurance, which,
Well, I'll cover it, I'll get to that in a minute. But Kathy, I can see in the future, if we're gonna divide this up like 6 per ward, and these permits are not transferable, I can see a situation where we've already allocated the 6 per ward, let's say. I'm assuming if somebody wants to apply, they'll go on a wait list maybe. And if they go on the wait list, and then all of a sudden, one of the guys that's already got his permit decides to sell to somebody else, I can see a conflict there where the person, buying it might think that it's automatically going to transfer, and he's buying it as an income property.
Well, you would have to fill out a new application, so he
What
could.
about the guy on the wait list? Says, wait a second, that guy's off. It's not transferable. I'm on the wait list. I'm number 1. I want that permit.
Sure. Well, that's fair, and that's something that could be outlined in.
yeah,
in the-
they could be transferable. Again, it's,
Well, hopefully the buyer would be smart enough to say, well, look, that's part of the consideration for me purchasing it. On the insurance, I see that asking for insurance there, but then it goes under the standards. On the insurance, that certificate should actually do 2 things. One, show the property as a rental property, so we don't get in a situation where the insurance company's providing a homeowner's policy thinking it's the primary residence of the person, and therefore, should a claim arise, they could deny that claim, which causes problems for everybody, which also means we should have the city named as an additional insured on the policy, or as a certificate.
I think we need to consult with our insurance expert in order to properly draft that.
John, can you restate that? So I can
I
follow
think
it?
you just volunteered
Go ahead,
there,
say it
Councilman.
again.
Well,
How does
there are
that
2
work?
different policies. A homeowner's is intended to be issued as your primary residence. where rental property almost becomes a commercial policy in itself.
Right.
And is covering them for the fact that it's being rented for loss of rents and so on. The reason for naming the city as an additional named insured, as opposed to just an additional insured, it gives the city the same rights as the policyholder. So therefore, there's no conflict as far as any question with who the policy applies to.
Does that cost the insurer more money
It-
or anything?
it
How-
could,
what-
because,
what do you do in order to do that, I guess is
Well,
what I'm
be-
trying to say.
First of all, you're gonna have to, your standard homeowners is just issued, like they say, the house is $300,000, and then you automatically get so much in contents coverage, which is normally 60%. You get so much in additional coverages, whereas on rental property, you gotta not only put down the addition, you gotta say how much you want as far as loss of rents. If there is a fire or claim and it's closed up for 4 months and you can't rent it, you can purchase that coverage, if you want. You don't have to, but, you know,
Should we ask for like an additional percentage for umbrella type of policy too?
no, I don't think so, because the $300,000 should be sufficient. I mean, because a claim, the defense of the claim does not detract from the coverage itself. So you can have $300,000, you could spend $200,000 in defense costs, you still have $300,000 for the claim.
Okay, okay, sounds good, makes sense.
That's the only questions I have.
Definitely learned something today.
It gets us to permits again.
Well, and then we go into
think I
renewal,
we
which
could
we,
do that.
which we touched on, the renewal of permit, after application, renewal of permits is on that.
Oh, gotcha.
I did get an answer for you, Ms. Dowling. Roughly 1,300 registered rentals, not counting apartments,
1,300.
Family.
Okay.
Those are-
single family. Yeah.
or
Thank you.
duplex.
Yeah.
We're up to renewal, which I think we touched on and took note of your comment there, Mr. Krieger, about transferability. If you look at number 3 on that, short-term rental permit holders shall be required to provide evidence that their rental has been occupied for a minimum of 60 days during the previous calendar year to be permitted to renew their permit. Again, kind of goes in line with the idea, if you're going to be limiting these, you want, if the point, one of the goals of this is to provide that level of accommodation within the community, you want to make sure that they're actually being used and you don't have an underutilized asset which is sitting vacant a lot of the time, which obviously, as we know, can become a nuisance just by the lack of use. Where are we?
Standards, which is,
Go ahead.
at the bottom of page 4 are the standards. This kind of gets into the heart of what we would be looking for, is in part, when the application comes through, there's a guest capacity limit, which Mr. Flipiak touched on, based on the number of bedrooms, multiplied by 2, and then 3 additional guests, assuming you may have a common area, that may have a pull-out sofa or something like that. But then that's your max. So if you have a 2-bedroom house, then you're at, 7 guests. That could be your maximum. And that does not count children under the age of 3. This number of bedrooms would be verified through the inspection process. And at the time of at the permit issuance, we would also identify what those maximum number of guests are on the actual permit that's issued. Mr. Philippi, I've talked about the parking. This kind of goes into a little bit more detail here. Again, the key being we want to make sure that there is a space available and accounted for that's on an improved surface or in a garage, but that is based on at least a minimum of 1 parking space per bedroom plus 1 additional space. If the short-term rental location cannot meet that requirement of 1 per bedroom, the applicant shall indicate the number of spaces provided and restrict their guests to that number of vehicles. So if they just don't have the availability in their driveway, then that would be something that they would want to account for. And The next page on page 5, I think this is important. Accessory buildings, no guests of the short-term rental can be allowed to utilize an accessory building for sleeping,
You know, sleeping in sheds or tents.
and no tents and campers or anything similar to that outside the main dwelling. We did reference the inspection process would be based on the existing inspection standards that our code enforcement office already uses for our long-term rentals, and that would be under Title IX of the Rental Housing Maintenance Code. So there's a reference there of where the inspection process would take place. This item E is an interesting one, and we found a couple of examples of this, but basically you're putting the onus on the applicant that they by signing an affidavit attesting to not only what they've put on the application, that they're also abiding by non-discriminatory standards and so forth. I have a couple examples I can provide at a later date if you're interested in looking at those. But again, it's putting the onus on the applicant, which I think is important to say. You know, we attest that we are not in violation of other state rules and will comply with all non-discrimination acts and disability acts and so forth. Other information, special events would be prohibited, so you can't hold a wedding or anything like that. You can't have a party in their backyard other than what would normally be allowed for a dwelling for somebody living there. And then there's a reference to the noise ordinance, trash requirements. Signage would be the same requirements that's required of any dwelling under the rules of Chapter 1171. Talked about insurance. Tax, obviously, that would be something that would be ironed out. We would want to know where the advertising of the dwelling is placed. You know, is it, you know, what websites it's on, and also, is this a VRBO, is this an Airbnb, et cetera. And then record keeping, that's put on the applicant as well. They have to keep records of every guest that's there, the dates, the duration of stay, number of guests, and even price per night, and they have to keep those records for a minimum of 3 years.
That's, again, pretty common, and again, requiring those records to be available upon inspection just ties back that I'm sure the county would be very agreeable to something like that as well, because again, it ties back into any fees or taxes that would be required of that property.
Certainly, we would iron out what the rental tax is, that's why it's highlighted there. The fees, obviously, whatever you decide what the fees are. Current fees for a regular long-term rental is $200. Again, that's every 2 years. The violations and revocation, this is certainly subject to further amendments. These were just some general guidelines that we felt were pretty standard across other communities that are currently enforcing them. They can certainly be tweaked as appropriate. If you have any questions on those, obviously you'll want to take a moment to read those. The penalty section is strictly based on the language that was in Ordinance 24-0-072. Obviously, that's subject to change, but we just decided to use that as a starting point. The other thing that's interesting, too, is the appeal process. If anybody's aggrieved by a decision, where does that go? And I think that's open to interpretation as well.
Yeah, again, I think what we're presenting to you is really the substance of what we think go into a common framework of regulation and rules. Fully expect that the law director would craft this in a more comprehensive and complete manner, but these are the things that we think should be in it. And again, for example, obviously that applies to penalties. We would apply something similar to those penalties that exist currently for similar situations. But appeals, that's another one up for debate. You know, that could be BZA appeals, that could be a special commission that can be made up of internal administrative persons. I mean, communities do that differently. So again, that's open for discussion on that. But that's the essence of it. You know, essentially you have a limited number of permits offered. You have limitations on how the homes can be used, what the occupancy can be. You have prohibitions on certain activities. You have limitations on where within the city they can remain. And you have a limitation on the number of these overall within the city that can exist. I don't think there's anything in here that is too terribly onerous. I also don't think that it's, I think that is pretty much what we would recommend as kind of a bare minimum of regulation.
Thank you, Ken. Kathy. I'd like to ask the opinion of the law director, who hopefully has something brilliant to say.
He usually does.
He usually does. Well, first,
I mean, a more specific question. I haven't been asked to do any analytical review of anything that the administration has drafted, and so I don't.
so looking at this, Joe, would this have to go in front of the planning commission? Is it a zoning issue?
Yeah, the way the charter is written is anytime you start determining what land uses are or are not permitted on a district basis, I think the planning commission, we would err on the side of caution and refer it to them for recommendation. It kind of goes beyond just a general business regulation because the proposal would differentiate where what districts is permitted or not permitted in. So I would err on the side of caution just to avoid any future legal challenges that it was not properly enacted and recommend that referral.
Okay. Ken, the other thought that you and I have talked about before is a community survey. This is a neighborhood issue, and, if this is going to go into neighborhoods, I'd like to kind of get a sense of what the community thinks about Airbnbs, short-term rentals. What do you think of that idea?
Well, I'm going to leave that up to council to decide whether or not, we should do that. We would certainly are able to do that, and it wouldn't be difficult. We've done it for other issues. I mean, I think, generally speaking, most people would probably tell you they'd prefer not to have them. I feel pretty confident about that, but also probably those same people have used them in the past. So I don't know what your results will ultimately be. And again, if council directs us to do so, we'll happily do that.
Okay. Council?
Mr. President?
Yes.
Ken, or probably Kathy, let's just say that, for example, this is what we go forward with. How would this be handled in the administration in terms of the different departments and things of that nature? From issuing the permits or taking application, to issuing the permits to any type of inspections, the renewals. I mean, how would you guys?
Clearly a planning department function.
Okay.
Yeah.
So then the next question is, do we have the personnel in order to be able to achieve all this, because it's a lot of extra work?
Well, I can assure you that the planning director could tell you that they could accommodate it, but we would have to evaluate that as we go on. I mean, we do a lot of inspections, and as you know, I mean, this council has adopted a framework that requires all. You heard the number of just single-family homes we have. That doesn't include apartments and condos. Of which we have to do inspections on those. So I wouldn't say, obviously, this is a pretty small number. If you're limiting the number of permits, it's a drop in the bucket in terms of what we do on an annual basis right now. So I don't foresee any additional resources being needed.
Now, would there be, in terms of inspections, or say, for example, one unit, for lack of better words, a unit, I guess, there's multiple violations, whether it's multiple parties after another or anything of that nature. How would that be keeping track of over the course of the year? Because you're not going to wait a whole year or are you going to wait a whole year? What do you envision for that? So, for example, I stayed in one of those tree houses about a year ago for a wedding down in Cleveland, Georgia, of all places. And right there, big sign. Can't have more than, I think it was 4 people in the house other than, what you had. And part of it was because, it's a tree house, so things constantly swaying, so to speak. But other part of it's because they don't want to destroy the neighborhood, or because there's other people that live around it. So I guess how would you keep track of this over the course of a year so other people aren't affected?
Sure. So, we have a very good ability to track violations across our building and zoning codes, and we do that now with, with our current programs. You asked that question, this is one of the most important sections, I think, in this draft, or any community, which is the violations and revocation section. So, the benefit of reviewing these on an annual basis is you have the ability to review what happened over the prior year. If people are consistently violating the rules, you're going to have a record of that. Now, of course, like any other violations throughout our city, you have to rely on the neighbors to bring those to your attention. We have inspectors, code enforcement people that monitor zones within the city, but they're not going to be most of the time really focused on these. So if neighborhood complaints come in, we will investigate. Obviously, a lot of those, the things that we worry the most about, raucous parties and things like that, are going to come through our police department. So all of those violations or any problems or nuisance issues we will record, and all of that would be taken into consideration during the renewal process. That's why it's important to have both a penalty section and an appeal section. Obviously, we have to be mindful of due process on this, which is why, again, this stage we're at, council deciding whether or not you want to permit these at all, and if so, are we on the right track in terms of the substance? When it gets into that issue of enforceability, renewability, and the appeals process, we're going to rely pretty heavily on the law director to help craft that. But I think at this point, it's, do you want to do this? And are we hitting on the right sections here for that regulatory framework?
Thank you.
I don't want to none of us want to put a whole lot of effort into a very clearly defined area until we know, on the law department, and until we know if we're going to move forward with this.
Mr. President? I think the fact that the ones that have existed, although not in compliance, there haven't been any complaints at all from the ones that have been going on for some time. I would tell you that I've stayed in Airbnbs throughout the United States and Europe, probably 30 of them, and I've never had a bad experience. They're always pretty well kept. I will say I've tried to go with superhosts, which are people that had a lot of good reviews, and they get that recognition for being superhosts. Also, we have a lot of homes in the city that are rentals, and they're owned by out-of-town people. We're just talking about one, there's about 12 of them owned by a company in Florida. So I'd rather have someone who lives within 30 minutes or lives nearby caretaking or taking complaints than have someone that lives out of state that's going to constantly probably have code enforcement visiting their houses. So those are good reasons. I think it's a good idea. I'd also say I think we have what do we have, like 15,000 homes in the city?
Well, almost 20,000
Is
dwelling
it 20
units.
now?
Almost, yeah.
If you got 20,000 homes, I think 8 is a better number. I said, because we've already got all these people that are already doing it would apply right away because they're going to know about it. And once it's out there, these people may know people too and give them a heads up. And the city's not going to mess around. If there's a problem, you're going to have a problem with the city. So I think I think we're on the right path myself, and they serve a purpose. We mentioned, some of them mentioned people come in from out of town. They're coming in for a weekend where the hotels are full, or we had a couple years ago, we had a tornado come through. People need short-term housing. 30 days is a good number, I think. I think if someone's got a problem, their house had fire, they got 30 days in a short-term rental that they can utilize. So I think it works. It's good for the community. I know I've gone to when I coached baseball, we had a bunch of kids. We had Airbnbs, worked out real well. Because there wasn't enough hotels because there was a lot of activity going on in these smaller communities. So that's my 2 cents. So
Mr. President? Ms. Kirchner, I just, out of curiosity, you say we've had no complaints about these, but yet they're not registered with the city of Mentor, so how do we know that we haven't had complaints concerning short-term rentals?
Well, if there was a problem, like you mentioned, they mentioned parties or something, or maybe too many cars in the driveway, and then because neighbors are gonna
But if they're
complain.
not registered with the city of Mentor, the police department would have no reason to report it to planning department.
But I thought the administration checked those addresses for complaints, the ones that,
I don't know if they did or didn't.
that's why I thought I was getting that information, right? Didn't you check the addresses on some of those to see if there were complaints?
I can only speak to the property maintenance and code enforcement complaints. If there've been any complaints filed with the police department, I don't want to make any assumptions there, but for the ones that we were aware of, we weren't aware, the complaints that we were receiving was a question of if they were registered. So that was the complaint. So I guess, other than that, and kind of back to the point that Mr. Marr was asking, I mean, we have any complaint that we receive and we go out and do an inspection, we record it. You know, it's going to be recorded, especially now with our new permitting software system. Everything is recorded, and so it'll be tracked if there's any kind of violation, anything that exists. That affidavit that I pointed to earlier, that also talks about attesting. That person has to attest that they're in compliance with all regulations. Again, that goes beyond just the zoning regulations. So again, it puts the onus on them, and I would imagine, to Mr. Flipiak's point, that we would hear about it if there were any other problems from the neighbors.
Mr. President? As we were discussing before, it's actually, there was one LLC that I found that owns 17 properties in Mentor. And I'm not saying they're probably long-term rentals. But my point is, as we had a meeting last week, we have a shortage of single-family homes in Mentor. Of those 17, 14 of them are located in Ward 4. And that is an area for more of starter homes. So actually, that's taking a lot of properties off the market. You know, for young families, and we realize we're hurting in the young family and the seniors. So that's just my concern. And of these are the ones, the bills go to Florida. You know, and I know nothing about the properties or anything. It's no reflection on that. It's just one LLC that owns that many properties.
If I
President?
can I speak?
Oh,
If
Go
you,
ahead.
I would just make one comment on that. I think that's one of the motivations for us suggesting that you place a limit on them, because, number one, you wouldn't want was it 17 of those, for example, to be converted into short-term rentals, because we kind of assume that if there's going to be an issue, short-term is likely, with the turnovers, to be more problematic than long-term. And then I think, to your point as well, you want to meet the need that may exist within the community. To Mr. Kirchner's point, there is these are used, and they can be necessary for a lot of people. But you don't want, you want to place some limit on that so that you're not, so you're still providing that opportunity for permanent residents to have home options.
Mr. President? On the penalty phase, that's something I think we have to work out a little bit better, because of the fact, I just went through this in my ward, as you're aware of, and most of council, with a shipping container being used on residential property. And that individual has quite a history over the last 10 years of violations. And what we found is the individual wasn't even meeting the requirements. He wasn't even meeting, it was turned over to the law department. The law department, it was going to court. And it went to court, and this is what we're finding out is typical. Nothing against the judge, but it basically says, do you meet the requirements now? The planning or zoning people say yes, and the judge says, fine, court costs. No other penalty, which is not the way this should work. If that resident's gonna violate, in other words, right now, it's coming to a fact where people could say, Dad, don't worry about code enforcement. You don't have to pay attention to the building department. Just worry about when you have it done before your court date comes up, which could be way in the future. That I would like to see rectified.
You know, Mr. Krieger, you make some excellent points. I think that is one of the reasons why you have a section in here that would allow the city to review on an annual basis whether or not there's enough there, regardless of what happened through the court system, to justify not renewing. So,
Well, like I said,
You-
some of
you-
these people are habitual, and it's gonna, for 14 years, this was annotated and in writing, and I'm just saying that's way too long, and it doesn't serve the other residents of that neighborhood. It doesn't do justice for them.
yeah, I agree with you 100%. Again, for, at least with respect to short-term rentals, one more hammer you will have is to say, okay, you haven't operated very well within our rules, we're not going to renew.
Okay,
The
as long as you
permit,
stick to it.
yeah.
Well, Council, I think this is a great point to end this conversation.
Move to adjourn.
Thank you.